dear colleagues, I open the workshop on Universality of the Rule of Law, Part A. So, rule of law is a constitutional principle which is valid all over the world. Of course, it is not respected, maybe fully, in some areas, but this does not hinder to call this principle universal. Universality, in my opinion, the universality of rule of law is necessarily linked with the values which are incorporated, which are a part of the rule of law. Because rule of law is not only legality, it's not only conformity with legislation, it is conformity with the Constitution and with the values, the basic values of a Constitution. And these basic values are human dignity as the most important, and connected with this, the principle of freedom and equality. And these three values, they constitute a functional unit. And there is no rule of law without respect of these values. So they are incorporated. The modern view of a rule of law is, in my opinion, the respect of public power of the state, of law, but law, not only legislation, but constitutional law. And necessarily, explicitly or implicitly, in a constitutional order, these three basic values are existent, normatively existent. And for this, this is valid, I would say, for the law itself. And it is valid because rule of law is also derived from the human being. And for this, I think it's universality. But we see now, we hear, we can listen to the various perspectives. And first, I want to give the floor to the judge and former president of the Constitutional Court of Moldova, Ms. Domnica Manole. Yes, please.
Thank you, Professor. Thank you for the invitation. It is a pleasure to be present today here. Dear colleagues, dear participants, my address concerns the role of the Constitutional Court in protecting the principles of the rule of law, the sovereignty and the independence of the Republic of Moldova. Recently, the Constitutional Court of the Republic of Moldova ruled on the constitutionality of a political party that bore the name of its leader, the Shor political party. For the first time in its case law, the court analyzed whether the activity of a party violates the values protected by the Constitution. Article 41, paragraph 4 of the Constitution of the Republic of Moldova provides for the declaration of the unconstitutionality of a political party if the authorities demonstrate that it militates through its goals or its activity against political pluralism, the principle of the rule of law, sovereignty and independence, and the territorial integrity of the state. The government submitted an application before the court sustaining that the Shor political party, through its actions, militates against the political pluralism, against the principle of the rule of law, the sovereignty and the independence of the Republic of Moldova. The repeated, continuous and considerable violations related to the non-transparent financing of the political party, sanctioned by the courts of law in definitive decisions that had no effect and had not led to the correction of the conduct of the party. and action and statements of the leaders of the Shore Party that suggested to use of violence in order to overthrow or change through violence the constitutional order of the Republic of Moldova. The court held that the transparent financing of political parties and electoral campaigns, it is a principle underlying democratic elections. The court noted that the non-transparent financing of a political party is contrary to the rule of law. It has a systematic, continuous character and significant proportions. In order to analyze the extent of this phenomenon, the court also took into account the facts found by investigative authorities that were presented by the government to see if the information presented results in any danger for the values protected by the Constitution. The court took in account as well the documents regarding to the economic sanctions applied to the Shore Party and the person in the party's leadership by the authorities of the United States of America, by the Council of the European Union, and by other states. The court considered the resolution of the European Parliament of 19 April 2023 regarding the challenges faced by the Republic of Moldova, which emphasized that the Shore Party wants to destabilize the political situation in the country by offering financial incentives to vulnerable people to participate in anti-government protests. The court found that Mr. Shore left the territory of the Republic of Moldova in 2019 and was announced as a national and international wanted person in connection with his conviction in 2017 for causing material damage through fraud and abuse of trust in extremely large proportions and money laundering in extremely large proportions. Since then, the Shore Party began to receive financial support in a non-transparent way and in significant proportion. The authorities had applied different sanctions over time, for example, warnings, cancelling the registration of candidates, deprivation of allocation from the state budget for a period of 6 months or 1 year. However, the applied sanctions confirmed by irrevocable court decisions did not prevent the party and its candidates from committing new violations of the transparent financing principle. The court found that the non-transparent financing of the party is systemic, continuous, and in significant proportion and are incompatible with the fundamental principle of democracy and the rule of law. Arriving at its solution, the court accepted the position expressed by the Venice Commission in an opinion of 2022 for the Constitutional Court of Moldova, in which it was mentioned that the general situation in the country is an important factor when evaluating the use of means by a party improper or even illegal to distract voters from other parties or even using resources to undermine the fairness or integrity of political competition, leading to distortions of the electoral process through improperly obtained advantage supported by unauthorized foreign funding. From this perspective, The court could not overlook that the protest actions at the financing of the party that intensified in the fall of 2022, immediately after the outbreak of the war in Ukraine, a war that also has a negative impact on the security of Moldova as a neighboring country. The court noted that the order projected by the Constitution requires a system with political parties that adhere to and respect the rules of the democratic game. Parties that engage in activities contrary to the values of the rule of law cannot benefit from the protection of the Constitution. The court declared this party unconstitutional and applied the theory of militant democracy, according to which society must not commit suicide by allowing parties to use its free and accessible processes to demolish those very processes. In conclusion, the court held that the activity of the shore political party undermines the democracy, gravely affects the principle of the rule of law, and jeopardizes the sovereignty and the independence of the Republic of Moldova. Thank you very much.
Thank you very much, dear Judge Domnica Manole. This shows very clearly that democracy is, of course, a constituent element of a rule of law. Democracy is a political freedom, and freedom is connected with human being, with human dignity, as our constitutional court several times has stated. And so the political parties as elements of democracy, they, of course, they must not attack the constitution, and not a suicide, as you say, of democracy and militant democracy. This is something which our constitutional court in the 50s of the 20th century has always underlined that this exists is very important. Thank you so much. Very interesting to that. Now, I would like to give the floor to the judge of the Constitutional Court of Romania, Gheorghe. We modify a bit the program
for 10 minutes.
And yes, it's so. We are happy that you are in part A and not only in part B. Yes, so I give you the floor.
Okay, first of all, dear Professor Reiner, I want to thank you for the opportunity to be here today and address you at this prestigious World Law Congress. Esteemed colleagues, distinguished guests, with the topic that I would like to approach refer to the guarantees of the rule of law in Romania in the digital area, age, cybersecurity and processing of personal data, which I consider to be the great relevance nowadays, and which was recently discussed in the case law of the Constitutional Court of Romania in a decision delivered in June this year. For my presentation not to exceed the time allocated by the organizers, I will briefly address some of the relevant issues. My paper will be sent in extenso to the organizers in order to be included in these Congress papers. The concept of rule of law is very well known and highly debated. However, various national models of rule of law exist nowadays. The continuous development of digitization continues to bring to our attention the conceptualization of the notion of digital state or digital order. The existence of the internet and the multitude of digital databases has led to the emergence of previously unknown rights. And I refer here to digital rights, which are exercised within a specific space, the virtual space, where legal subjects appear as codes, nicknames, IPs, real, fake, or even stolen identities. As such, digital rights are not external to universal, natural, and rational human rights, but rather form our common body with the latter, and it is the states to grant them the same level of protection as that afforded to the other human rights. As rightly states in a specialized literature, in an ever-changing world where data has become the black gold of the 21st century, the digital transformation for which cybersecurity is an imperative for success deeply penetrates the process and business activities of individuals in all countries. The Convention for the Protection of Individuals with regards to automatic processing of personal data opened for signature on 28th of January 1981 and ratified by Romania in 2002, was the first binding international legal instrument in the field of data protection. Under the Convention, parties are required to take the necessary measures under national law to implement its principle in order to ensure on their territory respect for fundamental human rights in relation to the application of data protection, the protection of individuals, and respect in particular for the rights to privacy with regard to the processing of personal data. As regards the concept of rule of law, I recall in this context the recommendation of the Venice Commission, frequently mentioned in the case law of the Romanian Constitutional Court, contained in the report entitled Rule of Law Checklist, adopted in 2016, and containing a list of constitutive elements of the concept of rule of law. Thus, the core elements of this concept are legality, including a transparent, accountable and democratic process for enacting law, prohibition of arbitrariness, access to justice before independent and impartial courts, including judicial review of administrative acts, respect for human rights, non-discrimination and equality before the law. Ladies and gentlemen, the Constitution of Romania starts by defining and characterizing the Romanian states. The principle of the rule of law is governed by the provision of the first sentence of Article 1, Paragraph 3 of the Constitution, whilst the 2003 revised Basic Law specifically introduced the principle of separation and balance of powers, as well as the principle of legality, a specific mechanism of the rule of law and democracy. The Romanian Constitutional Court's decision, which I mentioned at the beginning of my presentation, concerned an emergency ordinance governing the general legal regime for the establishment, administration and development at national level of a hybrid cloud infrastructure, the government cloud platform consisting of a private cloud component as well as of certified public resources and services of other types of public or private clouds. According to the Legislative Act, the government private cloud is administered from an operational point of view by the Romanian Authority for Digitalization and consists of a set of computer, communication and cybersecurity resources owned by the Romanian states, interconnected at service level with public and or private clouds. In other words, the platform provides direct access to the personal data of employees of public institutions and individuals who have access to these services, which is stored on the platform, whereas it is the state that administers their public services. However, the frameworks for the management and storage of data on the platform is carried out by decision of the executive. Furthermore, the policy, strategy, technical and operational criteria for the implementation, operation, maintenance and further development of the government private cloud, the rules for determining the agreed level of services, as well as for migration of data, or where appropriate interconnection of information system is also to be established by government decision. In this context, the complaint of unconstitutionality concerned the fact that the contested act established by the possibility to regulate rules at primary level, relating to the storage, processing, access, definition of categories of data, including personal data, as well as to laying down general criteria to insurance, confidentiality, security, interoperability, and migration of such data by means of a government decision, which is a secondary legislative act, and not by law, or at least a legislative act having force of law, although the activities referred to were directly linked to fundamental rights to private, family, and personal life. Consequently, the question which in fact arose was whether the issues regulated by a government decision had to be regulated by law. That is to say, whether the principle of legality as a component of the rule of law had been observed. I make no secret of the fact that there was a heated debate and a dissenting opinion was formulated. I confess that I was one of the authors of that opinion. Our position was that the measures adopted under the law subject to constitutional review were not precise and foreseeable, since essential aspects relating to the retention and storage of data were to be regulated by secondary legislation, which does not always entail a transparent, controllable, and democratic adoption process, and is therefore not capable to providing public reassurance that the measures are strictly necessary in a democratic society. In our view, the limitation of the exercise of some personal rights was not accompanied by sufficient safeguards to ensure effective protection of citizens' personal data against the risk of abuse and unlawful access to and use of personal data. In the end, the court dismissed the objection of unconstitutionality as unfounded and ruled that the processing of personal data was subject to primary national regulatory acts and to the general data protection regulation adopted at EU level, to which the contested legislative act made direct reference. As such, issues relating to the storage, processing of access to personal data benefited from regulation at primary level and compliant with the standards and requirements of the existing primary regulatory framework. The specific way in which the platform operated and in which confidentiality of personal data was ensured was described in the Enforcement Act, which set forth in detail, specified and singled out those issues from a technical and procedural point of view. As there are issues relating to technical details, they can be regulated by government decision. Therefore, the court found that the constitutional guarantees relating to personal, family, and private life, as well as Parliament's role as sole legislative authority of the country, had been complied with. Dear participants, finally, I would emphasize that I brought this case to your attention in order to demonstrate that the rule of law in the digital area is a concept that not only does not become absolute, but is more topical than ever. A state governed by the rule of law must guarantee fundamental rights, whereas the challenges and risks that may affect them are ever growing. It is true that the existing mechanism must be adjusted in such a way as to adapt to new social realities in accordance with the requirements of the rule of law, namely stability, foreseeability, and clarity. Thank you very much for
Thank you very much.
Thank you.
Dear Judge Georgistan. It is really very significant that the digital state impacts rule of law, and rule of law must be made, digital state must be made compatible with rule of law, but rule of law is flexible enough to overcome the challenges of the digital state, and the fundamental rights protection, of course, is much impacted by the digital situation, and nevertheless the function must remain the same, and we but we must take into account indeed how the risks and dangers have, let's say, accumulated by the digital threats. But I think it is able to be overcome by the concept of rule of law. But thank you for this analysis. Now, I would like to give the floor to the President of the Supreme Court of Albania, Mr. Sadushi, Sokol Sadushi. I'm happy that you are here, and so I give you the floor. Yes. Yeah.
Thank you, Professor Arnold. Congratulations for this organization. I will speak for legality of administrative action in the Albanian Supreme Court's case law. The rule of law constitutes the cornerstone of liberal democracies. It is both on an overarching constitutional value that permeates the system of governance and the set of enforceable rights. At its barest minimum, it means that the exercise of power is subject to the law and that the government cannot act arbitrarily. The concept is here understood is encompass both procedural and substantive constraints upon the exercise of political authority. In other words, it is not adjusted and in-process requirements, but must provide the minimum protection to certain substantive values. Therefore, legality is one of the most important elements of rule of law that requires official action in a democratic state to be positively authorized by law. My paper will primarily focus on two significant decisions rendered by the Albanian Supreme Court. The first case, Merushe versus Social Security Institution, 22nd of July 2021, deals with legality of quasi-judicial organ and its impact on the right to benefit social security. The applicant has suffered for years from health conditions which causes permanent incapacity for work. Therefore, she claimed a special pension as foreseen by the law. The competent administrative authority decided that the applicant's health conditions is not severe. As such, she is able to conduct less heavy or easy work. The applicant challenged its decision before Albanian courts, which decided in different manners with regards to the questions if the decision of the administrative authority is final and binding and therefore may not be reviewed by a court of law. These questions has a previous history, which involve also the European Court of Human Rights. In case Dauti versus Albanian, as of 3rd of February 2009, the court decided that the administrative authority charged to finally decide on social benefits because of health condition is not a judicial organ, and as such either its decision should be reviewed by a court of law or it should be composed in such manner that its composition and functioning should be according to the criteria of a court of law, quasi-judicial organ. After some legal amendments approved by Albanian Parliament, the case came as last before the Supreme Court, which raised the questions if the new administrative authority complied with the requirement of Article 6 of the European Convention of Human Rights and Article 42 of the Albanian Constitution, which oblige a judicial review of all administrative acts. It is worth mentioning that owing to the raised questions about the conformity of national legislation with the European Convention and the national constitution, the Supreme Court initiated a judicial review of a law before the Constitutional Court, which refused to deal with it, underlining that it is a question of legal interpretation and not a constitutional one. Therefore, interpretation or natural legal framework in light of the Convention, falls under jurisdiction of ordinary courts. Based on that argument, the Supreme Court revised the case and found that in administrative organ with quasi-judicial competencies because of its final and binding decision should be considered as a court of law, and as such, it shall comply with the respective requirements of Article 6 of the Convention and Article 42 of Albanian Constitution. The actual composition and functioning of administrative authority failed to meet its requirement, and consequently its decision should be reviewed by a judicial organ, court of law. Since this is an unified decision of the Supreme Court, which aims to interpret the law with binding effects for all lower courts, all decision of the administrative authority for granting social security shall no longer deemed final. They can be challenged before the court of law, despite the provisions of the law in force. It is the first instance court decision that enforces the European Convention of Human Rights, directly ignoring the respective national legal provisions. The second case, Hanem Mohamed versus Ministry of Interior, 1st of February 2021, is linked with the legality of administrative action of the government during deportation procedure of a foreign family resident in Albania. After many years, the Minister of Interior decided not to renew the permit, and they were deported in the origin country without giving them any explanation, but only based on a letter of intelligence service that they further say in Albanian would not be recommended. There is no other evidence or proof or any other documents giving any further indication which and why and which member of the family are not to be granted a resident permit. Knowing the facts that there are 4 minors, one of them is Albanian citizens, born in Albania. The minister's decision was challenged before the ordinary court, which found it in conformity with the law, which foresees the discretion of the executive to decide to whom should be given the residence permit. Therefore, a court of law could not re-evaluate the decision based on information gathered by Secret Service, which could not be debated over before the court. The Supreme Court, while agreed that the granting of residence permit is at the discretion of the Minister Interior, underlined that the applicants and the court should be informed by the national authority of the reasons for his expulsion, according to the law. Furthermore, it stated that the merely former assessment of the reasons for the expulsion by the court is a breach of Article 8 and the 1st of the Protocol 7 of the European Convention of Human Rights. The court found several deficiencies in administrative actions. The existence of top-secret documents as stated by the Minister of Interior without disclosing its content, at least before the court. The lack of other factors that should be taken into consideration in the case of deportation, such as that the plaintiff had lived in Albania for 13 years. The fact that the expulsion included 3 minor children, one of them Albanian citizens, or the fact that no criminal proceedings have been initiated against the plaintiff in Albania, and absence or evidence indicating inclusion in any of the legal grounds that justify the expulsion from the territory of Republic of Albania. All of them did not comply with the principle of legality of administrative actions according to Article 4 on the Constitution. Consequently, they have led to the disregard of the guarantees provided by the obligation to protect the fundamental rights to a peaceful family life, as well as the special protection that the state must guarantee to the family and children. To conclude, the 2 aforementioned recent decisions of the Supreme Court highlight that although that requirements of legality principle could be formally and prima facie foreseen by legislator. It is for the court to assess its conformity with the rule of law in a given case, especially if there is a concern for potential violations of human rights and freedom. By doing so, the court effectively upholds the legality principle and as such ensures the governance according to the rule of law requirements, which could oblige the national legislator to adopt the legal framework accordingly. Thank you.
Thank you very much, Mr. President. We see clearly that on the one hand, constitutional courts, they, let's say, they protect rule of law, but the ordinary courts are the pillars of rule of law, and they have to apply legislation, legality, yes, and legality, of course, today, as you have also underlined, in conformity with human rights, in conformity with the Constitution. So, yes, rule of law gets its life in particular from the courts and also, and in particular, from the ordinary courts and on the top, the Supreme Court. Thank you very much for this illustration. Very fine, thank you. Now I give the floor to Alexander Tanase, my old friend, if I can say so, former president of the Constitutional Court of Moldova. And yes, now, dear Alexandro, please take the floor.
Thank you. Thank you, dear Rainer, dear colleagues, dear friends. Usually, in such events, we used to speak to you to talk about our case law, about the new decision of the Constitutional Court, but now we live in another world, and this is why also I decided to switch to other issue. And I decided to approach today a crucial issue that focuses on preserving the rule of law and advancing human rights in our world. Honestly speaking, I was inspired by the principles of our Congress encapsulated in the motto, peace through law. I used to say that even I was born in 1979, I consider myself, from my constitutional philosophy, a child of 1989. It is the year when the communist regime crashed in Eastern Europe, when the Berlin Wall fell, when the Ceausescu regime in Romania was destroyed. And the ruins of the communist world, we built a new system. We thought that we built a new system based on the religion of the rule of law and the human rights. You know, dear Rainer, that we many times discuss about the principles of the rule of law. It was in Regensburg, it was in Alba, Iulia, and Chișinău, and Vilnius, in many places. We had burning discussions and debates regarding the internationalization of the rule of law, of the constitutional law, about the constitutional identity. I remember your interesting articles about the evolution of the theory of Montesquieu, how this theory will look in 21st century, how actual is this theory, about the principles of and values of the democracy, starting from Thomas Hobbes, Hans Kelsen, and Carl Schmitt. But all of these things happened before 24th of February 2022. Today, we live in absolutely other world. Absolutely other world. Today, discussing about, after the atrocity that was committed in Ukraine by Russian military troops, philosophizing about the abstract principles and values and discussions remind me the situation where the troops of Mehmed II attacked the Byzantine Empire, and the primary focus of the Patriarchate of Constantinople was not to defense against the Ottoman Empire and the survivor of the country, but they was involved in the burning discussion, burning debate regarding the angel's gender. This is what happened now in the world. In 1992, Francis Fukuyama proclaimed the end of history as an era of unquestionable victory of democracy. However, the aggression against Ukraine demonstrates that this era is far from over. Contrary to optimistic predictions after the collapse of the Soviet Union, the world has not made significant strides toward widespread adoption of democracy. The use of brutal military force and it is now very popular. The war in Ukraine waged by Russia, it's a horrifying illustration of the conflict between brutal force, between tyranny and democracy. The Russian threat not only puts insecurity in Europe in danger, but also poses the most significant challenges to the international order, presenting a grave concern for the democracy in the world. Russian ambitions and intentions have been known for over 2 decades. However, it was easy for the Western country to close their eyes and indulge in wishful thinking, fantasizing that Russia was moving toward a so-called original liberal democracy or original democracy, how they called it. Indeed, the Kremlin, using military force, black money, corruption, and deliberately undermined the democratic order in the world. This lesson is a clear reminder that the concept of originally democracy, it's a falsity. Democracy either exists or does not exist. Dictatorship do not arise out of nowhere. Typically, everything starts with the violation of constitutional principles, of the manipulation of the constitutional text. The first violation of a constitutional norm sets up a domino effect. The violation of the Constitution leads to a growing avalanche effects of violation against democracy, eroding the principles of the rule of law and endangering individual rights and freedoms. Ultimately, society loses the very foundation of its existence. Violation of the Constitution is an expression of contempt toward its axiology. It is also a disregard for its axioms. The Constitution ceases to be a foundation and boundary for the public authority actions. It becomes a false justification for abuse of power. Therefore, the atrocities committed in Ukraine by Russia did not begin on February 24th, but longer before. They started when Vladimir Putin annulled the constitution, when through manipulation of the rules and the limitation of 2 consecutive presidential terms, he transformed into absolute monarchy that has lasted for over a quarter of a century, when repressive laws turned constitutional guarantees for human rights into fiction. When constitutional courts become a docile instrument for validating of abuses or political decisions. That's when it all began, and not on 24th of February 2022. Establishing authoritarian regimes is often justified by claiming that it strengthens the state. We can often listen to this so-called argument. However, the state ends up becoming increasingly weakened because a state in which the constitutional body violates the constitution, it's a weak state. Moreover, the state loses its sovereignty to the dictator because a state in which constitutional bodies do not act is not sovereign. The dictator confiscates the sovereignty of the nation to manipulate and abuse the law. The state's institutions lose their legitimacy and effectiveness by disregarding constitutional principles and violating the Constitution. Furthermore, if constitutional bodies fail to act and assert their authority, the state finally loses its sovereignty to the dictator. Authoritarian regimes trigger epidemics of authoritarianism. Such an epidemic of repressive law, which has been spreading in recent years from Russia, is now affecting countries that were traditionally being considered democratic. I used to work now in Central Asia, and I can see many examples in this regard. For example, in Kyrgyzstan, Kyrgyzstan was considered a democratic country in Central Asia. They tried to promote the same package of law on foreign agents, copy-paste from Russian Federation. Just a few days before, the president of the country introduced a draft law that effectively grants him the authority to review the Constitutional Court's rulings. The president of the Constitutional Court of Kyrgyzstan should be together with us today. He was invited, but he cannot attend to this even because the president prohibited him to leave the country. And it's happened in democratic country. It's real, more or less pluralistic democracy in this country. And they copy all of these rules from Russia. In the fragile democracies, the governments are tempted to fool the society, offering a distorted social contract where security is proposed in exchange for freedom. The history vividly teaches us that those who choose security at the extent of freedom finally risk losing both. In this context, an effective and functional system of constitutional control serves as a kind of insurance against such harmful choices. I used to say during the time to my students that the fight for the rule of law and the human rights never ceases. This is a battle that we are obliged to carry out consistently and transmit to future generations. The sleep of reason produces monsters. You know this famous expression of Francisco Goya. And this statement is more relevant than ever in our present days. We must be aware that the illusion of victory in the battle for democracy can have dramatic consequences. It's axiomatic that the most of the time dictatorship ends with war. Stalin, Hitler, Muammar Gaddafi, Saddam Hussein, Putin have drowned humanity in bloodbath. That is why the international community must react not when rivers of blood flow, when democratic mechanisms, but when the democratic mechanisms start to be dismantled, when constitutional terms are restarted, and when the laws are adopted to make free alternation of government impossible. The disorder of totalitarianism must be eradicated in its embryonic phase. At this stage, international sanctions must be imposed. When soldiers shoot people in Ukrainian city Bucha just for fun, sanctions no longer have the desired effect. The international community must take proactive actions to prevent the escalation of dictatorship into war. I want to conclude that humanity has often demonstrated its capability to prepare its funeral pyre. If we do not want to passively witness the decline of our civilization, the fight for democracy, the rule of law, and human rights must be embraced globally. We can create a world where freedom and justice prevail by upholding the rule of law and the human rights principles. Defending democracy is not just an option. Our responsibility is to pave the way for a more inclusive and harmonious world, ensuring a prosperous future for future generations. Thank you, dear colleagues.
Thank you very much, dear Alexandru. And yes, the rule of law challenge today is to, well, how to face illiberal democracy, or as you call this, weak democracies or even non-democracies. And just in extraordinary situations as we are now regarding Ukraine, yes, we would think perhaps that rule of law has lost its existence. But I'm nevertheless optimistic, because these great ideals, these great concepts, they do not die. They cannot, I think. And so as we are here to, let's say, to proclaim the revival or the continuation of existence of these principles. So this goes on, and I'm nevertheless optimistic that the good principles will prevail. Thank you so much. Now I give the floor to Judge Marjana Semini, Constitutional Court of Albania. Thank you so much, and please take the floor.
Thank you. Honorable Professor Reiner, honorable member of the panel, ladies and gentlemen, it's my pleasure to be together with you today. I come from an academic experience, a long one, and at the same time a very short one of an experience as judge in Constitutional Court, because I am just elected this January. I was very interested to be part of this activity, because for me it's important to fight for the rule of law, for respect of this important principle. Upon learning the program of the activity, I thought it might be of great interest to discuss a little bit about crossing points of universality on one side and rule of law by the other side. So every time I hear or read about universality, my mind keeps a design of a triangle with human beings in one corner, with nature the second corner, and the third, society. From the point of view of human beings, we all have the same anatomic construction, the same vital organs, the same senses, despite the fact that we have different colors of eyes, of hair, of skin, and different immunity systems. So universality is with us from the moment we are born until the moment we'll go away from this world. On the point of view of nature, we all are living under the sun, the same sun. We breathe the same air. We have the same nature around us. From the point of view of society, we live in our countries, and every country is a state, and every state has a form of organization. So the binomial state and legislation is everywhere the same, is universal. Now, the first question that was raised in my mind was, what results come out because of the union of universality with rule of law? First of all, I think it is the field of human rights. When we talk about human rights, we begin with the Universal Declaration of Human Rights. And it is a document, a universal one, that's signed by 194 countries. It means that it's ratified, is applied, it's protected in all the world. So this is a document that is incorporated in constitutional systems of each country. And I think this is universal everywhere. Besides of this very important document, there are a lot of treaties and international conventions that are ratified by the greatest number of the countries in the world, such as those that are related with children's rights, with labor rights, ILO conventions, and so on. Second, I thought to analyze the universality of rule of law together or in context of constitutionalism, because it is very positive to underline that the rule of law is an important principle that's provided by every constitution in the world. So it remains a fundamental value that is turned in an important document of universal character, despite the specifics that might have, case by case. At this point, institutions created by the Constitution and in order to defend the Constitution, such as Constitutional Court, Supreme Court, and so on, are very important, and despite the fact that might have different names, they have the same objectives. The role of the Albanian Constitutional Court is also noted in the restoration of the decisions of the general jurisdictions. And we have more than 85% individual claims by citizens that are asking or claiming their rights in order to prevent the violation of the principles of fair process, of discrimination, and violation of reasonable time, and etc. The rest of the claims for the abstract control of the normative acts are represented by NGOs, by groups of interests, or parliamentary groups, etc. again. The third point I wanted to share with you is that I want to see universality of the rule of law in the context of an approach, but also of a behavior. It was discussed previously by different panelists today. As an approach, it is expressed in the organization of a state with three powers: legislative, executive, and justice. The rule of law is related with legislative process because every state, every country wants to have a clear, a stable, and publicized legislative process. Legislative processes by which the law are adopted, are enforced, is and has to be fair and efficient. This is one of the objectives of the rule of law. Dealing with the executive power, it should be characterized by a good and, by a good and fair governance that has to be constructed based on the principles of the best interest for the public interest. The third power belongs to the justice. The justice should be accessible and impartial. And this has to be everywhere in every country. So in this point, we again see the universality. At the same time, in every country around the world, justice should be delivered timely by competent, ethical, and independent bodies. So this kind of triad of powers is similar everywhere in every country. If we analyze now the universality of the rule of law as a behavior, it is related with accountability. Everywhere we have an organogram of different institutions that have high officials vested with powers. So any public official is accountable under the law. As such, universality of the rule of law has the same allies, at the same time, the same enemies everywhere. Because abuse, corruption, organized crime might be present everywhere in every country. These are the same challenges that are faced by old democracies, but at the same time by new democracies. Specialized prosecutor offices aiming, investigating, and sentencing officials on duty who abuse their power are instruments that assist the respect of the rule of law. Anyway, I went to a certain point that's called a rhetorical question, and I thought with myself, and I wanted to share with you too, why it is easier to investigate and to judge the corruption of ex-officials vested with power than those who are still in power. I know that if we'll enter in this kind of discussion, we must stay per days and find arguments, but I just wanted to light a yellow point in order to say that why is it so? And it's not only in my country, is in your country, is everywhere the same. The conclusion that could be said is that rule of law is a boundless principle. It has the same universal meaning everywhere, but might not have the same application everywhere. Universality is combined and cohabit with diversity. The countries are distinguished by each other because they have different ways how they give, analyze, or check and balance for their good governance, how they measure continuously the performance of institutions and performance of their officials. So now I am almost at the end of my speech. The world remains always a universal scene where most sensitive or sensational events related to the respect or violation of the rule of law are played. And we all, as citizens, but also as officials somewhere in our institutions, are spectators, are the biggest audience that's the same universal everywhere. We see what happens with our institutions, with our leaders, and other people just have a look on us, seeing that how we are performing our duties. So I think that it's a kind of struggle. It's a struggle between impartiality, independence, and honesty towards corruption, abuse of power, and other vices. But since I closed with the behavior, I think that we need to be courageous. We need to be brave enough, and we need to be together with each other, because together we can go far. Thank you very much.
Thank you very much. So, yes, together we can go far. Yes, and I also think I agree that there is universalism, but there is, of course, the perception how it is applied could be very different. The perception, I distinguish between normative reality. Rule of law is a universal normative reality, but the perception is different, maybe, and there are differences, of course, as you have underlined. I think the diversity, this is something acceptable and maybe desirable even, but the functional core must be the same, and it is, I think, at least in an ideal concept. But thank you very much for also pointing out the elements of universality. So now I give my floor to Miroslav Granat.
Thank you.
You know that we all are bound to our 7 minutes rule, so I must apologize, but I did not invent this rule. You know that.
Okay, thank you. I would like to say a few words concerning rule of law in Poland, and especially few remarks concerning the position of the constitutional judiciary in Poland. And I titled my presentation Rule of Law in Poland and Dilemmas of Constitutionalism, Dilemmas of Contemporary Constitutionalism. But firstly, I want to thank, I'm privileged and I'm honored to be among you. Thanks for invitation by association, and thanks Professor Rainer Arnold. This is the pleasure to cooperate with you.
My pleasure.
So what about my remark concerning the Polish case, Polish experience in the rule of law? So I'm sure that you know that Polish Constitutional Tribunal was destroyed a few years ago by the government, by the majority, by the populists. And this was the shock to me and to us, to legal doctrine in Poland. But the effects of this destruction pose a challenge to the rule of law in Poland. And this is very interesting to us, to research, etc. So I would like to skip at the stages of the destruction of the rule of law in Poland, as especially the position of the Constitutional Tribunal. Polish Constitutional Tribunal had a beautiful position under the 1997 Constitution, but systematically, step by step, the government destroyed this position. I distinguish takeover of the tribunal thanks to the quasi-judges, loss of authority, and thirdly, the tribunal in the hands of the governments. This was 7-8 years ago, but in fact, indeed, today, this is the history. So I would like to say about the actual situation. So what's next? Remake the tribunal in the future, redesign the tribunal in the future? It is possible or not? So I don't have a solution for what should be done after the crisis of the constitutional reviewing in Poland. But the answer of the question, what next, according to me, should be considered on several levels. The first level looks at the types of constitutionalism functioning in Europe and in the world. The rivalry between them, for example, between the liberal constitutionalism, because according to me, constitutionalism, in fact, this is the same as a liberal constitutionalism. But obviously, we have the varieties of political constitutionalism, like, for example, populist constitutionalism and other. So the rivalry between them seems to be the subject of disputes among specialists in Poland, but in fact, we are in the center of these disputes. Thus, the establishment of specific review institution depends on the resolution of great political and ideological dispute over constitutionalism. Unfortunately, among my opinion, in Poland now, the populism, the political constitutionalism, populist constitutionalism won, and liberal constitutionalism lost his position. But the second level concerns institution. It seems unlikely that the Constitutional Court in Poland will be restored in the form in which they existed since the 2018. So I think about the position of the Constitutional Court in Poland under 1997 Constitution. So restored is impossible, according to me. Reproducing Constitutional Court in a one-to-one scale is probably unrealistic. they have lost their authority, and the tribunal is dependent on the legislative and the executive branch, which they used to control. It is quite sad, but this is true. In the case of my country, we are considering dispersing judicial review to common and administrative courts. According to me, this is a very just way and very just solution for the future. Dispersed review should complement centralized review. It remains to be seen whether it should be an emergency only in this period with the populist constitutionalism, or it will be a permanent solution. However, we believe in Poland that it can be effective at least in times of populist constitutionalism. What is of key importance here is complementing one type of review with the other. Perhaps limiting the strong position of the Kelsenian Constitutional Court. The Polish tribunal was a typical Kelsenian Constitutional Court, is a price worth paying in order to maintain the rule of law. The rule of law is more important than any institutions or any ideological project or different thinking. However, I don't know if it is possible to switch from the Kelsenian model to another model of review immediately. I think about our situation in Poland. Isn't this a radical change resembling the cutting of the guardian knot in constitutional law, probably? I'm in favor of the dispersion of constitutional review, but such a proposal must be carefully considered. For example, in the case of Poland, exercising judicial review by judges now is facilitated by the principle of direct application of the Constitution. Our 1997 Constitution must be applicable directly. This is the first way of application of the Constitution among our Article 8 of 1997 Constitution. And my tentative conclusion, I can see no alternative to the rule of law in Poland. However, proposing specific changes in the field of judicial review must be responsible. From the Polish perspective, that from the perspective of the destruction of the Constitutional Tribunal, the dilemmas facing constitutionalism are more clearly visible. However, we do not view the destruction of the Constitutional Court in Poland as the end of the world in Poland, as the end of the rule of law in Poland, because functioning the constitutionalism in Poland now without a constitutional tribunal. It is possible in practice. So we do not view the destruction of the Constitutional Tribunal as the end of the world, but as a piece of the constitutional mosaic of the modern world, in the arrangement of which we try to participate. Thank you very much for your attention.
Thank you very much, dear Miroslav. Yes, the situation in some countries are not ideal in this sense, and you are somebody who is very close to these developments, and as a former constitutional judge, you yes, have exercised your function in a good situation, and now you are pessimistic on that, and you plead for a decentralized constitutional review by all the courts based on the direct applicability of the Constitution. What I think is connected with the Constitution is always directly applicable insofar as it is possible. Thank you so much. Now I have two further speakers, which I welcome very cordially. This is Judge Fiona Papajorgji from Papajorgji. Thank you. I'm learning a bit Albanian pronunciation. That's good. And this is then after her Julita Milovine from Lithuania. So please, Fiona, go on.
Thank you very much, Professor Arnold. It's my first time to participate in this Congress, and I do like to thank you for this opportunity to talk about the universal dimension of the rule of law. Although this is a very broad concept, through my paper, I will try to give the Albanian perspective of the universal dimension of the rule of law. Principle of the rule of law represents one of the main pillars of democracy and guarantees that no one stands above the law. There is a close link between the rule of law, democracy, and fundamental rights, as emphasized by some authors. It is hard to conceive of democracy and fundamental rights, at least in the context of European liberal democracy, without the rule of law. Without the rule of law, there is no equality under the law, no genuine concept of the governed, or effective protection of fundamental rights. At the same time, without democracy or fundamental rights, the fundamental assumption and objective of the rule of law would be put into question. This triangle is at the very heart of the constitutional identity of the European countries. For the Albanian constitutional system, the universality of the rule of law has been decisive in order to fulfill its aspiration to be integrated into the Euro-Atlantic organization, which considers the rule of law as a fundamental value that derives from common tradition of the member states, being therefore a precondition for this membership. On the other hand, Constitutional Court, as a guarantor of the Constitution, has laid the foundation of the rule of law, mainly focusing on the principle of legal certainty, separation of powers, as well as the protection of fundamental human rights. However, the globalization process has influenced the transformation of the traditional concept of the rule of law. The recent events are striking. The pandemic and the war in Ukraine have created extraordinary situations that generated extraordinary measures which interfere with fundamental rights. The governments have issued law of emergency, putting a real risk to the system of check and balances on which the democracy is based. Therefore, at this very moment, the role of Constitutional Court is crucial in restoring the balance between powers. Such actions were also undertaken by Albanian authorities, and the Constitutional Court was put into motion. Regarding the pandemic, in one of its decisions of 2021, the Court reviewed an order of the Ministry of Health prohibiting gathering of more than 10 persons and political meetings until the second order. The applicant, a political party, claimed that the order violated the activity of political parties, the principle of equality before the law, freedom of assembly, and freedom of expression. The court held that the order restricted the freedom of assembly as well as the freedom of expression. It was approved on the basis of a legal provision and pursued the public interest, health protection from an infection, and widespread disease. Nevertheless, the phrases "until a second order" indicated that there was no clear deadline where these restriction measures could end or be reviewed. Thus, the principle of proportionality was violated. On the other hand, the war in Ukraine impacted the internal market, and the government interfered, establishing two separated boards to control the prices of food and fuel. The boards were established by the normative act with the force of law, which is an exceptional type of legislation to be approved by the government in case of emergency and necessity. Such acts were challenged by a group of members of parliament on the same grounds. The condition of necessity and emergency were not respected, and the substance, the economic freedom, and equality before the law were violated. The first decision of the court is related to the Control Board on food prices. The court found that the explanatory reports of the normative acts did not contain any assessment of the emergency and necessity. Thus, it was not possible for the court to analyze the compliance of the act with the Constitution. In the second case, related to the Control Board on the fuel prices, the court found that this time the government has analyzed properly the current situation on fuel prices fluctuation. Thus, the constitutional criteria of necessity and emergency were met. Regarding the substance, the court concluded that assigned to the fuel board the competence to terminate the specific emergency situation created arbitrariness and violated economic freedom. So one article of the Act was repealed. In conclusion, I would like to reiterate that the rule of law is in constant evolution, and its universality offers a common framework that guarantees human rights and stability, promotes public trust in the justice system, and is a safeguard against the arbitrary exercise of power. Nevertheless, efforts to achieve the universality of the rule of law have their own challenges, being in mind the European integration process, which requires the approximation of domestic legal order with the European one. In this respect, joint efforts should be done in order to ensure that the rule of law is not just a theoretical concept, but a reality touched by everyone. Thank you very much for your attention.
Thank you very much. Very interesting now to see also and to continue to analyze jurisprudence and yes, rule of law is in development also in the perspective of the constitutional courts, and but it's something which is conformed to a development towards universalism. And yes, you mentioned also, and I think very rightly, that European Union supranational order is also promoting rule of law, because, and this is what we have also in Poland, this problem, but that the common values must be, well, the same at the community level or the union level and the national, the member states levels, and this gives impulses, important impulses to propagate also the values. Well, thank you so much. And now, last but not least, not at all, least, Julita, I would like to ask you for the floor.
Okay, thank you very much. Just like previous speakers, I will begin by extending my words of deepest gratitude and appreciation to Professor Rainer Arnold for the possibility and the honor to be included in this panel, so thank you very much. And I should fit in 7 minutes in order not to steal a lot of time from the next panel that will continue to discuss similarly important matters. My intervention and the certain perception of the universality of the rule of law today is related to the situation in Central and Eastern Europe in the second half of 2021, when Lithuania, Latvia, and Poland was faced with the unprecedented flow of migrants, but not unusual migrants, as we all understand, but the flows provoked by the undemocratic regime of Belarus. Stories of migration law phenomena are everywhere. Southern Europe countries like Italy, Greece, or Spain have faced it for many years due to the hostilities in the Middle East, Africa, or Asia. However, for the more northern countries, the massive flow of migrants came quite unexpectedly, especially as the military aggression in Ukraine had to have started only in half of a year, and the relative prosperity of the region was not disturbed at the moment. So thousands of migrants crossed the borders of neighboring countries of Belarus, seemingly out of nowhere. National authorities as well as European institutions call the phenomena a hybrid attack, meaning that it is not a normal irregular migration of people running from the unsupportable situation in their homelands. The migrants from Middle East were transported by plane intentionally to Belarus and were used as the instrument to punish the states actively supporting Ukraine's pro-European direction. The concerned states, seeking to preserve their national security, adopted some rules in order to face the crisis. And at each instance, it's not only the migration, but the intertwining of migration and legal control of it, which attracts the most of attention. The state of emergency was declared, and some measures to control the situation were introduced. The most of these measures contested is so-called in the law temporary accommodation of migrants in the designated places without the right to move freely in the country for the period of time that could last up to 6 months and without any intervention of the court. Moreover, a few months later, in February 2022, after the military aggression in Ukraine's territory, another wave of migrants were at the borders of the same states, Latvia, Lithuania, Poland, as well as other European states. But however, in this time, the institutions of those states reacted differently. And the rules applicable of the migrants of war was much more softer. They were offered with the full assistance as to the registration, the normal accommodation, the visa-free regime, and a certain social assistance. Nothing of it had happened with the previous migrants, arguing that the situation this time is totally different, and the context of unprovoked war in the neighbors allows to take the different, the privileged, the preferential measures toward Ukrainian migrants. So taking into consideration this twofold situation, the question may be raised today whether the rules concerning the migrant rights might be different depending on the context and the situation, and what are the limits of the state to protect itself and to protect its citizens from the hybrid attack. NATO summit in Vilnius 2 years ago emphasized once again the importance of the global security as the precondition, among the other things, of the proper implementation of the rule of law. Rule of law can prevail only in the state which is not threatened. The rule of law's values always come under distress when the national security emergencies arise. An example of Ukraine speaks loud about constant violations of the rule of law on a daily basis. Therefore, it is crucial for the state to deploy all efforts to ensure national security. Rule of law is vital for peace and stability, which is the security sector's job to provide. Therefore, as Catherine Doverne, researching the migration phenomena, has argued, migration law, in face of his global challenges, has been transformed into the last new bastion of the sovereignty of the state. Migration control is strongly associated with the national sovereignty, which is under the threat in various ways. The current era, therefore, re-emphasizes the link between the sovereignty and the migration, and in the process brings questions of migration closer to the core of the rule of law ideology. The rule of law is a multifacial principle, and the protection of human rights cannot be forgotten even during the state of emergency. But what exactly the principle of the rule of law requires from the state? To protect the state and its citizens, or to defend the rights of the migrants who, before their own will, attracted by fake promises, became an instrument of authoritarian regime. Namely, with this dilemma, Lithuanian Constitutional Court was confronted when it was brought to decide whether the measures introduced during the irregular, unusual migration crisis are in line with the Constitution. The court advanced rights-based rule of law approach, balancing between the need to ensure national security and the rights of irregular migrants. In its ruling of 7 of June 2023, Constitutional Court decided that it had been in conflict with the Constitution of Lithuania, the aforementioned general rule, according to which in the event of mass influx of foreigners during a declared state of emergency, absolutely all asylum seekers, without any exceptions, were temporarily accommodated in the designated places without the right to freely move within the country, which was considered by the international jurisprudence as simply detention, without any intervention of the court. The Constitutional Court stressed that the inviolability of human liberty imply protection not only against arbitrary detention, which is allowed by the Constitution, but also against any, with certain conditions, of course, but also against any other unlawful restriction of the personal liberty, especially when the freedom of movement is significantly restricted. According to the court, the declaration of the state of emergency is not in itself a ground for such restrictions. The court emphasized as well the link between the restriction of the personal liberty and determination of human dignity, saying that every restriction of the personal liberty, even if it is lawful, when it is ordered by the state power institutions, is in contradiction with human dignity, so the issue is very sensitive. However, the liberty of the person might be subject to the limitation in order to protect the constitutional order of the state, as well as for the purposes of ensuring public order and state security. And it leads to the observation that the rule of law is not an all or nothing concept. The reality is that the existence of the rule of law is a matter of degree. The Constitutional Court, in the mentioned ruling, had paid attention also to the national security matters, and did it say that the measure that it evaluated, that quasi-detention of migrants should be repealed at all. Taking into consideration the state of emergency, such a measure can continue to exist. However, it should be applied with appropriate consideration of individual circumstances, even if the times of emergency, and less restrictive alternative measures also should have to be introduced. The decision of the Lithuanian Constitutional Court proves that the human rights dimension is what separates the rule of law from the rule of power, and the rule by law, as having law by itself, doesn't mean that it meets the requirements of the rule of law. Nevertheless, the credit to the national security was paid in the second case, when the states that suffered from the instrumentalized irregular migration hosted even bigger flow of migrants escaping from the war in Ukraine. The status of the war refugees emphasized the need and the justification of preferential treatment. Acting quickly and decisively, European governments have opened the borders, and European citizens have opened their homes in the unprecedented showing of solidarity towards refugees. The specific national legislations on granting temporary protection to all those who was in possession of any proof of escaping the war were adopted. The appropriate legislation on European level was activated as well. Supporting the refugees from the neighboring state fighting the aggressor also meant the concern about regional security and the efforts to redress undermined rule of law. Therefore, despite all the allegations of double standards, which were not challenged before the Constitutional Court, but there was the discussions about that, the differential treatment that can be called positive discrimination takes into consideration the special context and circumstances that turned upside down all the Europe. To respond to the critics of such arguments, if it is sufficient to recall that the prohibition of discrimination, which is an element of the rule of law, demands that people in comparable or relevantly similar situation must be treated equally. And I doubt very much that the ones who escaped the austerities of the war and who dream to come back home as soon as possible might be equal to those who purchased a direct plane ticket to come to Belarus with the hope to find the way to prosperous West. And instead of the conclusion that I wrote, I would like to recall the words of Justice Anthony Kennedy told during the opening ceremony, that we have to be very careful to do not lose the principle of the rule of law in our quotidian life. We have to be like that because the temptations are very numerous and the authoritarian regimes are very keen to contribute to it. Thank you very much.
Yes, thank you very much, Jolita. We see that migration law of course, is a challenge for rule of law. Indeed, we must not abandon rule of law, for migration in the situation of migration, of course. And as you say, well, this is a matter of degree, so maybe the principle of proportionality is a good, let's say, measure stick for our interventions into fundamental rights, legitimate or not. And so maybe in this sense, well, it's a matter of degree, this can say. Well, thank you so much to all the panelists of this first round. Yes, we have, it was very rich reflections you presented us, and now I would say we need a break of 10 minutes at least, but then afterwards there we will, as to the program, Professor Muravjov, then Vice Ombudsman Mircea Criste, then Professor Sergei Maximov, then Judge Remție Strefipeci, yes, okay, and last but not least, Professor Natalia Mushak. Is this right? Yes? Mr. Meyer, do you want to take the floor? I was not informed. Then to this is... Yes, you have, can you make the conclusive words, or now after the second, can you be in the second?
In the second panel, let me begin.
Yes, I begin with the second panel, but we must now make a break because yes, then you start and then Professor Muravjov the next, yes? Wonderful, so we are happy about this. Okay, then thank you, and yes.